Next on TBW, the state Supreme Court hears arguments involving the constitutionality of classifying marijuana as a substance illegal for all uses, including medical. This case was heard in Olympia on September 25th.
Supreme Court of the State of Washington is now in session.
Be seated, please. And we will begin with the first case. Good morning.
May it please the Court, my name is Melissa Burke-Kane. I'm an Assistant Attorney General representing the state of Washington. With me at council table today is Harold Dygert, Senior Assistant Attorney General. The issue in this case is whether the statute that places leaf marijuana on Schedule I of the Controlled Substances Act as part of a comprehensive drug control law and provides for administrative means to change that scheduling violates equal protection or due process. This statute provides vital public protections, and the attack on this statute and the trial court's decision are based on a flawed premise, and that is that the law must rise or fall based on its effect on one individual's interests without considering the full range of the public policy purposes advanced by the law. This morning I plan to address 4 areas. First, to briefly describe how the Controlled Substances Act works. Then to describe the nature of the constitutional challenge, the implications of striking down the law, and briefly address the due process claims raised for the first time by amicus. The statute is part of Washington's Controlled Substances Act, and it's a uniform act that's been adopted in one form or another by all 50 states. It regulates drugs that are being abused by placing them on one of 5 schedules according to 2 factors: their propensity for abuse or their currently accepted medical use. The schedules are not set in stone, and there are 2 ways to change the scheduling of a drug: either directly by the legislature or through an administrative process at the pharmacy board. That administrative process would create a full administrative record and provide for judicial review under the Administrative Procedures Act. But Mr. Seeley chose not to take his case to the board. Instead, he directly challenges the legislature's decision, claiming he is constitutionally entitled to access marijuana even though its use is experimental. He claims that the Controlled Substances Act violates that right and must be struck down. But the statute that has been challenged is a reasonable and a flexible way to regulate not just marijuana, but a wide variety of substances. It relies on objective criteria, and it's the type of public health and welfare statute that has been measured constitutionally by the rational basis test. And
Counsel, how is the public health promoted by denying Mr. Seeley the opportunity to smoke marijuana in his health situation?
There are 2 concerns of public health in this case. First, reducing the incidence of the abuse of drugs, because by attacking the statute directly, it is descheduled for state law purposes, not just as to a medical use, but for all purposes. And so there are the health effects associated with drug abuse, but also the health effects of this substance, which is essentially unknown, and there may be health effects which are not yet recognized. The other concern is that there is a public policy purpose which requires that we make sure that claims about drugs are substantiated before they're made available to the public. And so there are unknown health effects both to individuals and then larger health effects to society, the propensity of drug abuse.
Is there any dispute in this record that smoking marijuana, or Mr. Seeley smoking marijuana, cures his nausea, or makes him feel better? Is that disputed?
We cannot dispute Mr. Seeley's beliefs about marijuana and how it affects him. But the larger focus of this case is that there is no objective information that demonstrates, and in fact, the great weight of medical evidence is that it is not effective for any medical use, including as an antiemetic for cancer patients.
Counsel, are you aware of any study that has been conducted using accepted scientific methods that would indicate a valuable medical use for the leaf marijuana?
I am unaware of any scientific study which is a double-blind, randomized study of the type that's generally accepted by the medical community. I am aware of a study that was performed by Levitt, and that was a double-blind controlled study that compared leaf marijuana smoked and another drug that is a synthetic equivalent of that. And it demonstrated that while neither drug, neither use was particularly effective, the tablet form was slightly preferred by the patients in the study. And of course, that study was based on the objective scientific data where neither the subject nor the researcher knew which substances were being used, and that the subjectivity of the tests are a problem with some of the research that has been relied upon to support marijuana.
Counsel, was the synthetic THC available to Mr. Seeley?
I believe that it was, and I believe that that is in the record, yes.
Counsel, since, as I understand it, the synthetic form of THC was approved and is now on Schedule 2 and can be used under the care of a physician. Since that time, have other synthetic drugs been developed that are more effective or alleged to be more effective?
Yes, there are. There are a wide variety of new generation drugs that have been developed in the last few years. One of them was given to Mr. Seeley. It's called ondansetron, and that is in the record. There are also two more recent drugs, granisetron and dilasetron, and those have shown great promise. They're serotonin antagonists, and they're specific to the receptor centers. And in fact, they are vastly effective for the majority of people. Since this is a constitutional claim, history is under Washington's Constitution, history is important, and history supports this particular law, going all the way back to territorial days. Washington took an early and an active role in, it was almost unique for the times, protecting its population by regulating drugs and medicines. And in fact, that protection was deemed so important by the framers of Washington's Constitution that they made it a specific provision in Article 20, Section 2. That provision says the legislature shall enact laws to regulate the practice of medicine and surgery and the sale of drugs and medicine. And that provision, coupled with the legislative police power, is the source of power to enact the Controlled Substances Act.
Counsel, is there a similar provision to the provision that you just indicated the Washington Constitution contains regarding the right to legislate in regard to medication and so on? Is there a similar provision in the Oregon Constitution?
I am not aware that there is a similar provision. I know the history of our provision was drawn from the Texas Constitution, so I don't believe that it is in the Oregon Constitution, but I cannot say that with certainty.
Thank you.
So Washington, for a long period of time, has relied on objective medical evidence and the regulation of drugs made available as medicines. And if we accept the premise that is provided here by Mr. Seeley, we turn back the clock to a time when individuals were simply left to their own devices to decide what substances work for them and what substances might prove more harmful than good.
Counsel, if marijuana in its vegetable state was put on Schedule 2, that would be a determination of the pharmaceutical board, is that right?
It could be done in two ways.
Or by the legislature.
The legislature or the pharmacy board.
Forgetting about the legislature for a moment, the pharmacy board could do that, is that correct?
The pharmacy board would have the power to do that, but there are specific definitive factors in the act that they would have to assess, and there would have to be a full record to make that determination.
And if they did, then a physician could prescribe marijuana in the vegetable state then, is that right?
I don't believe that that is the case because of the parallel federal law. The federal law controls the prescriptive authority of physicians, and in order to prescribe a Schedule I substance, you need a specific authorization from the federal government. And so while it could be scheduled on 2, it would not necessarily provide a limit.
Insofar as state law is concerned.
As far as state law is concerned.
there's not much you or we can do about federal law. Insofar as federal law, or state law is concerned, a doctor could prescribe it then, is that correct?
There would be no state law prohibition to that.
You said Mr. Seeley had not requested any action by the pharmaceutical board. Has any, and this may be outside the record, has anyone else similarly situated done that recently?
That is not outside the record, and so I can speak to it briefly, and it's a very small reference in the record. There was a petition by an individual for rescheduling. That petition was denied, it was not appealed, but from the record we know that there was no medical evidence ever presented in that case, and so it's difficult to assess and certainly would not prejudge what the pharmacy board would do in a situation where it did review this particular substance.
Counsel, you've been talking about the question of marijuana to some extent, but what I'd like to focus on for a moment is the constitutional test for equal protection that's been advanced by the trial court and by respondent here. We've been talking about marijuana in the context of a rational basis for the Board of Pharmacy's scheduling and the legislature's decision. The test that's being advanced by the trial court and by Mr. Seeley is a different test. It would apparently require us to overrule our decision in Smith, at least the majority position in Smith. Can you comment on the equal protection test? Is the state constitutional provision equivalent to the 14th Amendment? And what about the test that's being advanced by the trial court and respondent here?
The claim that's being made here is under Article 1, Section 12 of our Constitution, which, as far as I am aware, has never been considered more protective than the 14th Amendment, the Equal Protection Clause of the federal Constitution. And I believe in the state's most recent decision, the Thorne case of a couple months ago, that test and that scope for the Article 1, Section 12 issue was reaffirmed. The three-tiered test that is used under federal law was reaffirmed. The test that was offered by the trial court, and it's being advanced here, simply finds no support in any jurisdiction that I'm aware of. Even the Oregon court, which Mr. Seeley has tried to look into as a source, would not recognize the test that's being advanced here. In fact, the trial court, it's very difficult to tell how the decision was arrived at, but it apparently simply did high versus low, some kind of a balancing act that has never been recognized, and I submit should not be recognized. The equal protection rational basis test is the one that should be advanced in this case.
The equal protection test that's customarily used is an objective one, looking to a rational basis or the less stringent standards for reviewing classifications by the legislature or governmental body. The test that respondent seems to be advancing is one that's very subjective. I have a particular concern with this particular enactment as against the interests of society. Can you comment on that as a constitutional test?
I think that there is great difficulty with that constitutional test. One of the concerns that is apparent is the approach by the trial court, which simply abandoned the longstanding principle that laws will not be struck down on constitutional ground when there is a debatable medical issue. And the logical implication of that type of approach really puts the trial court in the position of the legislature by trying to go drug by drug to try to determine if, under particular circumstances, there is a constitutionally protected right. It's certainly a very narrow and isolated test, and I don't believe that it is in the public interest to recognize it.
Counsel, under the Oregon test, although I don't think Mr. Seeley's brief goes into it in any detail, are there not classifications under the Oregon test, the pseudo classes, the real classes? I didn't really see that analysis done in any of the briefs, but I assume that's the point to which we were being directed when we were asked to give an independent analysis under our Constitution. Have you done an analysis under that Oregon test?
Yes, and I have extensively walked through that analysis in the reply brief of the appellant and looked at each, following up on a law review article which was, I believe in the Iowa Law Review, trying to walk through the Oregon cases and look at each way that they have approached their privileges and immunities clause. But I think the answer is probably settled by the Eels case, which was a very similar challenge to the one that we have here under Oregon's privileges and immunities clause, and in that case, the classification for marijuana was upheld.
Counsel, could you address the implications of the trial court's decisions beyond marijuana?
Yes. Beyond marijuana, if you recognize a right of this kind as the trial court did, we would essentially get into the situation where all drug regulations become vulnerable, because as the United States versus Rutherford case recognized, and that went into a great deal of detail looking at the kinds of problems that might occur if, in fact, you started taking this subjective view of drug regulation person by person. The Rutherford case, I think, answers that question and settles that point, and it rejected a right, even as to the terminally ill, to access an experimental drug. I'd like to reserve the rest of my time for rebuttal.
Mr. Seeley?
Thank you, Your Honor. May it please the Court. Ralph Seeley, pro se. This case is not about whether sick people should or should not smoke marijuana. They do it all the time. It's not about whether we can get marijuana. We get it by picking up a telephone. If any of you have any sick spouses, children, aunts, uncles that need marijuana, tell me, I'll make the phone call, you'll get a phone call. The drug will be supplied free of charge. One of the things that distresses me about this situation is that I hold these people who do this work to be heroes, and I feel uncomfortable having as heroes people who break the law. It's one of the things that leads me to believe there's something fundamentally wrong here, which is why I brought this under the fundamental principles clause of our Constitution.
Counsel, is there any distinction that you would ask us to draw between, for example, cancer patients who wish to have access to Laetrile, which of course was not recognized by the FDA, and which many people felt, at least anecdotally, was effective in battling cancer, and yet,
Yes.
Can you draw that distinction?
Yes, Your Honor. Read Judge Young's opinion. Judge Young's opinion is the most important document in that stack of documents that you have. And I plead with you, please read that opinion. It's well written, it's well researched, it's an amazingly precise document. It's at CP 505 through 663. The point is that the DEA's own administrative law judge said this drug is valuable. This drug, he stated straightforwardly that it is arbitrary and capricious to withhold this valuable drug from the people who suffer without it. And at that point, when the DEA ignored its own law judge's months and months of research and well-reasoned opinion and findings of fact, that's when the system became corrupted.
Well, Counsel,
federal system.
Counsel, excuse me, before you leave that, what studies can you point to that Judge Young relied on, which were conducted in a scientific method, with a scientific method, that would support the ruling that he ultimately, presumably he was overruled, because I understand it,
Well, it was overruled politically.
Well,
It was, okay, first of all, he relied on all the studies that were done until then, which was 1988.
and which of those were conducted using recognized scientific methodology?
Your Honor, as Judge Young pointed out, you can't do scientifically, well, first of all, anecdotal evidence is not unscientific. And one of the greatest scientists of the world today, Stephen Jay Gould, is one of the people who has provided this anecdotal evidence that we supposedly can't rely on. And you can read about that in the book that I cited, Marijuana, the Forbidden Medicine. In any event, if you're talking about a double-blind scientific test, It's virtually impossible to do. First of all, the feds won't give anybody the drugs. And I've documented that. The man down in California that spent 2 years getting the FDA's approval, and then the DEA won't give him the drugs. And he wants to do the exact test that I'm dealing with here. You see, the problem here,
But counsel,
THC
excuse me, but clearly the drugs were given to people to test with under the state therapeutic research acts that were passed throughout different states in the country. So, and
not double-blind tests.
oh, they
Your Honor.
weren't. They weren't. But I'm
That's
saying
right. How do
the
you do a
drug was.
double- But as Judge Young, I believe, in his opinion, addresses this problem, how do you do a double-blind test with marijuana? People know they're being given marijuana. They know it's tobacco or marijuana. They know it's a pill and not tobacco or marijuana. How do you do this test? You see, first of all, the feds won't give anybody the drugs to do it. And secondly, it's inherently virtually impossible to do that kind of test. But the tests that have been done, and I can't cite the names of them, but the one test that was done where smokable versus the THC tablets, there was a substantial number of people who preferred the effects from smoked marijuana. And Your Honor, you see that whole approach is bogus because the problem is you can't keep the pills down. I don't care that they have ondansetron, incidentally $10 a tablet. I can't keep it down. I need this stuff in my system. I need it in my blood for it to affect me. Giving me a tablet that I throw up 30 seconds later is not effective medicine.
Counsel, are you suggesting that we accept a test that would relate only to your experience?
No, Your Honor, I suggest that you read Judge Young's opinion. That is the pivot point of this case. Judge Young researched all the research there was to do. He spent immense amount of time. He took testimony in 3 cities, and he came to his conclusion. And I'm entitled to rely on that conclusion and use marijuana. Under State versus Diana, you can arrest me, but you can't prosecute me. Isn't that fundamentally wrong?
Counsel, in Diana, wasn't the defendant prosecuted? Isn't it just a question of whether or not you have a legal defense of medical necessity?
I have a defense of legal necessity. And the first requirement is that you have a reasonable belief that this drug is valuable. Read Judge Young's opinion. I have a reasonable belief based on a DEA's own administrative law judge.
And you would like us to adopt that standard for acceptance by the Pharmaceutical Board of marijuana, leaf marijuana?
Yes. Because it's the only well-researched document, the only well-researched opinion that exists. And it's been ignored for political reasons.
Counsel, isn't that a wonderful argument, the argument that you've just advanced for the Board of Pharmacy and for the legislature as opposed to the courts? I mean, is this really a matter of constitutional law?
Yes, Your Honor.
Given the fact that this branch of government is ill-equipped to do the kind of evaluation and testimony taking that the legislative branch of government or administrative agencies are equipped to do.
Your Honor, the testimony's been taken. The research has been done. Judge Young has provided us with the guidance we need.
Of course, Judge Young's opinion was overturned by the DEA administrator, and that was upheld in federal court.
Your Honor, it wasn't overturned. It was simply not adopted. They did not adopt his recommendation. But nobody said that his research wasn't done. They just parroted out the same list of horribles that Judge Young addressed in his opinions. Read the opinions that overturn, and you'll see each one is answered. You know, one of them, let me give you an idea of how ridiculous this gets. The big thing about the 400 unknown drugs that comprise leaf marijuana and unknown side effects. Every prescription drug comes with one of these. You usually don't get them, but if you ask for them, you can. And every one of them. In Superior Court, I used my asthma medication. This is a drug that is given to my significant other who has breast cancer. It's tamoxifen. It causes cancer. That's the side effects of this drug they give her. It's right here. An increased incidence of endometrial cancer has been reported in association with treatment with tamoxifen. Now, there's hard evidence, good double-blind studies. This drug causes cancer, but it's a prescribable drug. And yet, marijuana has side effects, so we have to keep it in Schedule 1. You see, each of these issues, so-called raised in these lists of horribles that they always cite, all apply to other drugs that are in Schedule 2 or even 3, 4, or even unscheduled drugs.
Counsel, your argument, I mean, I'm trying to follow your analytical basis. It sounds like you're arguing a rational basis test right now. And of course, as you know, all of our opinions in this state have found on an equal protection challenge that the scheduling of marijuana in Schedule 1 is a rationally related, or serves a rational purpose. So we'd have to overrule our prior cases on that basis. Are you arguing some other analytical basis on which we can decide this case without overturning both our precedent and basically not agreeing with the U.S. Supreme Court?
Yes, Your Honor, I am. First of all, I've asked that you adopt Justice Utter's analysis in the Smith case. Now, the court didn't so much refuse, the court didn't have to adopt Justice Utter's analysis in that case because he came to the same conclusion. You know, in the end, both analyses found the same result. The Privileges and Immunities Clause in our Constitution, I mean, what this case is about is whether the words of our Constitution have any meaning, our state Constitution. You are the people who can give this document power to make it mean what it says. Fundamental principles in Section 32. Look at the Privileges and Immunities Clause. It says, no law shall be passed granting to any citizen any privilege or immunities not granted to the same. Why do we have to talk about classes? I don't have to be a class of citizens. That's not what the Constitution says. This should not be melted into the equal protection analysis, where we talk about classifications.
Well, Counsel,
I'm a citizen.
Counsel, Justice Utter suggested that we follow Oregon's analysis, and Oregon does have classifications, the pseudo class, the true class, and they have different levels of scrutiny that they apply to each class.
Why?
Are you suggesting that we not adopt Oregon because it does have classes, but that we pick and choose, I guess, from?
My recollection is that it asks 4 simple questions. Does it involve a privilege and immunity? Was it properly advanced into law? And so forth. I don't recall the analysis of classes that you're talking about, Your Honor, and I apologize for apparently being unprepared to advance my own argument. But I also adopt the analysis set forth by the ACLU in their amicus brief, and incidentally, the opposing counsel keeps saying that you should not recognize an analysis brought forth by an amicus. Well, I cited the fundamental principles, and I don't know where we should turn for fundamental principles if not to our own Constitution. So it seems to me that these arguments are properly advanced.
Counsel, included in the constitutional provisions is Article 20, Section 2, which gives plenary authority to state government to regulate medicine and drugs. And part of the fundamental principles of the Constitution is that plenary authority given to state government to regulate in this area. I mean, we can't ignore that, can we?
I understand that, Your Honor, but I'm saying that in this case, this has simply gotten out of hand. The system became corrupted at the federal level. You know, Congress didn't say you can't use marijuana as medicine. Congress said marijuana is going to go in Schedule 1 for now, and it created a system to change things when they needed to be changed, and that system has been corrupted. It no longer does what it's supposed to do, and our state pharmacy board has simply gone along with that. And I'm saying that this is an unconstitutional deprivation of individual liberties. Now, you go to Article 1, Section 1 of our Constitution, and it says that governments are created, established to protect and maintain individual rights. What individual right is being protected or maintained by the state and their stand that we have to keep marijuana in Schedule 1. Who benefits from that? Not one citizen of this state. Every reason that you can say marijuana belongs in Schedule 1 applies equally, if not more so, to opium, to cocaine. Those drugs are in Schedule 2. There is no individual right being protected by this drug being kept in Schedule 1, despite the DEA's own judge's opinion
Mr.
that
Seeley,
this belongs.
The state in her remarks indicated that you had not gone to the pharmacy board to try to get marijuana put into Schedule 2. Do you want to respond to that, or why you haven't?
Your Honor, it had already been brought forth, and they had not done it. I simply looked up the record, and it said that it had been brought, and they had refused to reschedule it. I also have this simple reality. We have two parallel sets of rules here. We got the federal and the state. You got to start somewhere. You can't just forever say there's no sense in changing this law because they can't prescribe it anyway because it's a federal regulated, and likewise the feds can say there's no sense in changing it. State laws are going to keep it out anyway. If the pharmacy board simply changes the rule, then we're going to have state bureaucrats facing off versus federal bureaucrats, and we're going to lose. But a state constitution interpreted by a state Supreme Court, by you 9 justices, will preempt or will trump a federal bureaucrat.
Counsel, one of the arguments advanced that you haven't really talked about, and I didn't hear the opposition attorney talk about this, is the due process test. As I understand, that test requires the court to determine whether the regulation is aimed at achieving a legitimate public purpose, whether it uses means that are reasonably necessary to achieve that purpose, and finally, whether it is unduly oppressive on the individual. How would you apply that test to your situation?
Well, I just take it right down the list, Your Honor. I mean, for crying out loud, that's what I've been saying. It is unduly oppressive. It's overbroad. There's no balancing test here because there's nothing to put on the other side of the scale, and that's essentially what that is a balancing
What is
test.
the reasonable public purpose or the legitimate public purpose to be achieved by denying cancer patients the option of smoking marijuana if they want to, even if it's ineffective? I mean, what's the downside?
There is no downside, Your Honor. I mean, the legitimate public purpose in allowing it to be smoked is that it ameliorates a great deal of suffering. And this is not theoretical suffering. There's some theoretical benefit on the other side of the scale, but there was nothing theoretical about my vomiting and over myself in that hospital. Excuse my language, but this is not a theoretical issue. This drug ameliorates genuine suffering of the citizens of this state, and there's nothing but empty theory on the other side of the scales.
Counsel, you did go into a description of your own personal symptoms and so on. Just as a factual matter, was this did you go through chemotherapy more than once with these same symptoms, or have you had different symptoms?
Well, I've had different symptoms with different regimens of drugs, Your Honor. The particular drugs we're talking about that brought on those horrific symptoms were, I can't even recall. I don't see that it makes any difference. Different chemicals create different symptoms in people.
I did have another question too, and it's again personal to you, but there was a letter that you had your physician write, apparently asking for permission for you to participate in the Controlled Substances Therapeutic Research Act program, and you were denied the opportunity to participate because funding had been cut from that program. As I understand it, the program is now being funded again, and that research is being done at Washington State University to develop a tamper-proof type of marijuana, and so I would assume, though I don't know, that you would be eligible to apply for that again. Am I
Well, Your Honor,
correct?
I mean, the research is done. Read Judge Young's opinion. We don't need more research for one thing. And another thing, That's all theoretical stuff. You think the feds are going to give them any marijuana? I don't think so. They haven't given anybody else any marijuana.
Aren't they working on developing it themselves down at
Well,
Washington State University?
It may be, Your Honor, but the fact is that those of us out there dealing with these horrific symptoms are not influenced one way or the other by some theoretical program going on in eastern Washington. What we want, what we need, what we're entitled to under the words of our state constitution, if they are to mean anything, is for our doctors to write a prescription, give us the privilege of using the drug without arrest, the immunity from punishment for using this drug to ameliorate suffering. The same way as people who need morphine, dilaudid opium, cocaine are entitled to that privilege and that immunity.
Could I ask you, just because you've talked about the fundamental right to this drug under Article 1, Section 32, and it's really a part of a due process analysis also, could you identify what fundamental right you feel is that you're advancing here? What is your fundamental right?
My right to be free from needless suffering. I'm a big boy, Your Honor. I'll suffer for the benefit of my fellow citizens. I've served in the Navy and spent 60 days at a time submerged on a submarine, and trust me, it's worse than jail. You don't get mail, you can't see anything out the window. I'll suffer for my fellow citizens, but there is no benefit whatsoever to the suffering that people go through because they can't use marijuana legally.
Thank you, counsel.
Thank you, Your Honor.
Counsel, before you start, you've advanced essentially a police power argument in support of regulation or prohibition of smoking marijuana. Couldn't you make that same argument with even greater force and apply it to abortion or the prohibition on assisted suicide?
A police power argument in support of those, that is a very different type of right than is being advanced here.
How is it different?
We have recognized some fundamental rights, the right to procreation, marriage, family, and in this case, Mr. Seeley couches his rights in terms that are similar to a right to be free from bodily invasion. But the state submits that from a right to be free from bodily invasion, it does not necessarily follow that there is a right to affirmatively access one particular substance, and that is specifically what he is asking for. The right that he is asserting here is the right to access a particular drug, even though it's experimental.
Doesn't Roe versus Wade establish the right to access a medical procedure?
If we go back to the Smith case, earlier marijuana case from this court, the Roe versus Wade case was raised in a number of other fundamental rights cases, and yet that court distinguished the type of right to use marijuana that was being asked for, and that demarcation still holds in this case. I'd like to say one thing, and that is to start by saying that in reviewing the record to come here today and in listening to what Mr. Seeley has gone through, none of us can help but feel compassion and sympathy for what he has experienced, and I in no way mean to demean that. But as difficult as it is, we must look further. We must look at the consequences of recognizing the right that he is asking for on our ability to regulate all drugs. The Rutherford Court was faced with a similar problem when the terminally ill wanted to access Laetrile, and it is a difficult reasoning process to go through, but we must do it. The issue here is not sympathy. Sympathy is not the test for the law's validity. The issue here is the legislature's power to regulate drugs. Pure and simple. And Washington has taken a very open approach to that. We recognize research, now have funded research. We take a flexible approach in the Controlled Substances Act to be able to change scheduling when there is objective scientific proof to support it. And I submit that that is a valid statute and a valid way of regulating drugs. This is not a debate among bureaucrats. bureaucrats have little to do with this. These are public interests. Let me give just 3 examples. Who benefits from the protection of the law? Those who may be vulnerable and abandon more effective treatments in favor of marijuana. For the immunocompromised, because there is no way to make sure that leaf marijuana is purified, maybe that will be the result of research done at Washington State University, maybe not, but we still have the problem of quality control, and it is a real risk to the immunocompromised. That quality control problem needs to be resolved before marijuana can be recognized as currently available and safe for use in medical treatment, which is the test under the Controlled Substances Act. By expanding the scope of what we identify as what are fundamental or protected rights under Washington's Constitution and striking down this law, the essential policy-making function of the legislature and the administrative function and the expertise of the Pharmacy Board are just lost in the process. The state constitution has given a specific duty to the legislature to regulate in this area, and what that approach requires is for them to assess a number of competing needs, not just the needs of one individual, but the needs of many individuals who may be protected by the laws. And I would like to just note that in the case of the abuse of marijuana, there's a special vulnerability for adolescents, and that is demonstrated in the record. And that is a public concern that cannot be denied in this case, although the trial court refused to acknowledge that illicit substance abuse played any part in this case.
Counsel, it is a little difficult to understand it, so maybe you could explain it a little better, and that is that if this were a Schedule II drug, it would be under the strict prescription by a physician, and there would be certainly limits on the amount that was given. It's not as if cancer patients could disseminate large quantities, if that's what you're getting at. So could you explain how it is that we're going to have teenagers using this stuff?
I'll try to address that. It's difficult to assess from a narrow record that's directed towards deciding whether the line that the legislature drew here about marijuana is valid. From that to try to evaluate all the public policy implications of making it more available. But it is safe to say that the drug would be more available if it is moved off of Schedule I. Now it's not available for anyone. And I can point to Clerk's Papers 408, the experience of Alaska when it descheduled marijuana. The next step is unknown. The issue in this case is taking marijuana off the schedules. What happens next, I cannot speculate about. But in Alaska, when they took it off Schedule I, their adolescent use of marijuana climbed to #1 in the nation. So while we can't say with certainty what would happen, we do have a glimpse of what might happen, and the point that I would like to make is that we need a full policy evaluation of that issue.
Thank you,
Counsel, let me ask one question. In 1889, when the Constitution was adopted, what was the legal prohibition, if any, in this state on the use of marijuana in the manner Mr. Seeley suggests?
I do not know the answer to that question. I'm sorry.
We'll take a short recess.
All rise. What is the recess?